Question number 35, that is administrative tribunals and administrative adjudication are one of the byproducts of an age of intensive government, and in particular they multiply under welfare state. Elucidate, and regarding that we'll discuss the very appropriate and answers, such as the very necessities of modern government and the synthetic structure of the present society have given new problems requiring new solutions. The aspect of post-independence era in India has been dispensation of benefits by state agencies. Thus, laissez-faire has become an outdated philosophy. Redistribution of nation's wealth through legislation and executive action is an accepted philosophy today. There has been all around expansion of governmental activities, planning social, economical, labor welfare, health, employment, education, and other activities aimed at community welfare form some among the many functions of the state. In such a situation, the chances of disputes between the administration and individual citizens are considerable. Most of these disputes are minor and are based on facts which in most cases is of a technical kind. If all such disputes are referred to the ordinary courts, they will be flooded with work, and the courts should not be able to cope with this work. Apart, in many cases, not only the question of fact or law are involved, but the policy consideration are involved. What is expedient or in the public interest, or whether the performance is to be given to the conflicting individual interest, all are matters which require a different administrative machinery. Besides, the judicial procedure is most complicated, expensive, and in many cases expeditious and cheap. Adjudication is desirable, as modern era is an age of expertise. The judges are generalists, and it is very difficult for a judge to determine the technical facts. Consequently, in modern times, where it is anticipated that disputes may arise between governmental agencies or between a government agency and a private individual, the law makes a provision for the determination of the dispute by an administrative adjudication rather than a court of law. The change and extended role of modern state has influenced the method of governments. So the French Council d'Etat acts as an appellate court from the decisions of administrative tribunals. The cases of conflicts between the administrative courts and ordinary courts or settled by the tribunals. This habits in France and in West Germany since the Second World War. Reforms. The administrative disputes are decided by administrative tribunal, and in case of United States of America, the American Federal Administrative Procedure Act 1946 is an instance of such basic structure, and in case of England, the Chalchley Down case triggered of the Franks Committee, and in 1955 the Franks Committee made a report, and the report submitted by the Franks Committee enabled the enactment of Tribunals and Inquiries Act 1958, and which is now in a consolidated form in the name of Tribunals and Inquiries Act 1971, which prescribed for the constitution and working of tribunal. Thus we see that the growth of tribunal was in fact a new system for the dispensation of justice, which was felt as a compelling necessity. The conception of welfare state caused unexpected growth in government activities. Intensive industrialization gave rise to multiple problems, the solution to which required technical and expert knowledge, and which the ordinary courts lacked. Therefore, appointment of tribunals became a necessity. So, industrial tribunals, employees, insurance, court, compensation tribunals, tax appellate tribunals, together with many tribunals, have come to play a part in the life of ordinary citizens. So, these are the reasons which made direct and indirect contribution in the very growth and development of administrative tribunals, and tribunals are established under law. Although the members of the tribunals are appointed by the government and mostly they are officials, yet they work independently without being influenced by the government. It makes its determination or orders while acting judicially, free from technical rules of procedure and evidence of court of law, keeping fully in view the social needs and accepted public policy, and all decisions of tribunals, whether created under Article 323A or Article 323B of the Constitution of India, will be subject to the High Court's writ jurisdiction under Article 226 and 227 before a division bench of the High Court within those territorial jurisdiction. The particular tribunal falls as it was decided in the leading case L. Chandra Kumar versus Union of India in 1997 by the Supreme Court. So we found certain characteristics of that administrative tribunal. So, those characteristics of administrative tribunals are administrative tribunal is not a court, it is not executive body, it stands somewhere midway between a court and an administrative body. It is a result of the compromise between the executive and the judiciary. It is established by the executive in exercise of and in accordance with the statutory provisions. In other words, it is established under a law and that is by a statute. Also, it is required to act judicially. It performs the quasi-judicial functions. It does not perform purely administrative or ministerial duties. So also, its proceedings are often deemed to be judicial proceedings within the meaning of Section 193 and Section 228 of the Indian Penal Code, and in certain procedural matters, it has the powers of a civil court, and so also it is not wedded to the technicalities of the rules of procedure and evidence as prescribed by the Code of Civil Procedure of 1908 and the Evidence Act of 1872. In other words, it is not subject to the strict rules of evidence as mentioned in the Evidence Act. So also it decides non-conventional type of disputes in aid of the program of the welfare state in accordance with the rules of natural justice. In other words, it has to follow the principles of natural justice in deciding cases.